All right. So this is the podcast series brought to you by ITSS Verona, a not-for-profit international cultural association dedicated to study of international security. My name is Oleg Abdurashitov, and I represent AI and cybersecurity team. And I'm joined here today by Mattia Ostini from the human rights team. 2 weeks ago, the United Nations concluded negotiations on the final draft of the United Nations Convention Against Cybercrime. Some call this agreement a landmark step in fighting global cybercrime, and others call this new convention unnecessary, flawed, and even nothing but trouble. With the final vote by the UN General Assembly expected later this year, we wanted to better understand the convention's history and future implications. With this, I'm happy to introduce our guest expert, Anastasiia Kazakova, Cyber Diplomacy Knowledge Fellow at Diplo Foundation. Anastasiia, welcome and thank you for joining.
Thank you for having me.
All right, so really, the first question is, you have been following the developments around this convention since what, the early days, like back in 2019, when Russia and 17 other co-sponsors proposed to establish the ad hoc committee on cybercrime. Do you really think that the world needs another cybercrime convention, or whether the world needed the other cybercrime convention at the time? No, it's not the only one, that there are other mechanisms like the Budapest Convention, mutual legal assistance treaties, Interpol, and other platforms. So was that a necessity, really?
That's a very good question. I think everybody at the very beginning asking themselves, what is really a necessity about a new legally binding treaty, a first landmark cyber treaty? Well, I would say that as a balanced, probably neutral researcher, which I'm trying to be, probably yes and no. Obviously, there are some benefits probably with this legally binding treaty, which hopefully provide more sort of the framework for many states that are not part of the regional frameworks to now have a clear ways to cooperate with other states to combat cybercrime. This is the hope for many in civil society and industry, but also experts who followed the process. There are, of course, many concerns with overall process regarding human rights safeguards, and I'm sure that we will talk about this in detail. But overall, that was also a question that we had, which surprisingly states actually adopted final text, which I think really few people expected. And I just remember we had an expert roundtable with civil society, industry, and representative of the Council of Europe to discuss what are expectations before the final session. And just remember that nobody really was sure that states would accept the final text, but they did. And yet, currently, we're just also in my team trying to better understand the gist of the adopted treaty, and we're trying to compare how is actually different the adopted UN text from the Budapest, which is considered sort of the established standard in this field, despite that we have a replica document, Malabo Convention, and some other instruments that have been cited by states themselves. And still we see that significantly the UN convention doesn't differ much from the Budapest Convention, which is good because it relies on really established efficient, so far, of course with its own disadvantages, but still efficient legal framework. But still there are some really important nuances, and again, I'm sure that we will talk about this in detail, which raises a lot of concern. And I just wanted to highlight that the text is still not formally adopted. So it is adopted by the ad hoc committee, and everyone waits for a formal adoption in General Assembly. And for the past week, we've probably seen new calls from civil society to vote against and not to adopt the text. But at the same time, there was a really interesting remark from the lead negotiator in the US saying that the US need to vote in favor of this treaty. Otherwise, that would pass a confusing signal to allies that they put so much effort in this document. So yeah, probably that would be my 5 cents to positive and some of the negative concerns regarding this process.
Oh, that's a lot to unpack, but you actually predicted my next question. You mentioned that there are a lot of similarities with the Budapest Convention, but what are the few differences that you may highlight, and maybe what are the few differences in the process of adoption of this new convention, because the process being somewhat different from the more traditional UN approach, so to say?
Yeah, I would start probably outlining the one tremendous positive difference in the way how the process was organized. The process compared to, I think also to the way how the second protocol of the Budapest Convention was negotiated, but also how we see the process taking place in the first committee of the UN, where states also discuss cyber threats, but in context of international security and peace. This ad hoc committee, the third committee process, allowed a really transparent inclusion of many stakeholders in this state-led negotiations. And with so many civil society, industry, regional organizations such as Interpol, for instance, taken really active part in sharing the views on the contents of the convention. They were also given specific slots to speak, even though those were limited. But anyway, that was really helpful. After each session, there were transparent publication of all submissions of all the concerns that we could also study. But again, during the negotiations process, and by the way, we reported from every session of the ad hoc committee negotiations, I think we've seen that states were split in 3 major camps. Someone probably would disagree that there are only 2 camps, but I think there were 3. Evidently, the first 2 camps with different views on the scope, terminology, on human rights, safeguards, provisions on international cooperation chapter. But also, I think there's a third camp of states who didn't explicitly join any of the first camps and also had their own views and purposes, sometimes that may coincide with the views of any of those camps. So from the very beginning, we've seen significant disagreements, and I just would outline 4 contested issues. The first is a list of offenses. Russia, as well as some other countries, particularly Iran, Syria, North Korea, wanted a comprehensive list such as terrorism, extremism, drug trafficking online, among others, to expand this treaty to include more cyber-enabled crimes, comparing to Budapest Convention, for instance. And Russia argued that if such offenses are not included in the final text, which they were not included, so there should be additional protocols developed over time. And surprisingly, we're already seeing the reports that states push for development of the additional protocols while the final text is not formally adopted again in the General Assembly, which again raises so many concerns across civil society. The second contested issue was about the human rights and safeguards. Largely, there was 2 camps from the very beginning. Countries who were saying that this is not a human rights convention, this is a criminal justice convention. Countries included Iran, Russia, China, sometimes India, some other states, who mainly concerned with the too many provisions in the text. They did not oppose at all human rights articles, but they were concerned with way too, as they argued, way too detailed wording on human rights safeguards. But I just remember, I think at the 6th session of the HSC, there was really an interesting proposal coming from the European Union delegation. They wanted to include a detailed list of safeguards to ensure the protection of personal data in line with the GDPR, of course. And I remember that even Elias, for instance, the US delegate also wasn't really sure that as a good idea, arguing that is also not a personal data protection treaty. That's, again, a criminal justice treaty. So human rights were really one of the most contested issues that cause divides between states. The third area is the international cooperation. There were main issues around whether states should have obligations to cooperate on any crime, or just offenses listed in a treaty, or any electronic evidence related to serious crime only, which eventually was the position taken by states to serious crimes as they are defined in the treaty. Bottom line, I would say that the UN Convention adopted with a really broad definitions, sometimes providing broader areas for the cooperation compared to the Budapest Convention. However, and in the analysis that we're going to publish, I think in upcoming week, we've seen that while the UN Convention provides for different areas, for instance, capacity building, technical assistance, which are not part of the Budapest Convention, still the Budapest Convention provides more targeted specific measures to cooperate between states. And in terms of the safeguards, even though the criticisms that we heard with regard to both instruments, the Budapest Convention was also criticized, as well as the UN Convention is heavily criticized. Still, in terms of the safeguards, there are largely concerns with the UN Conventions, which a lot of provisions are left to the domestic laws. So states would need to decide how and when to interpret and apply those provisions. And this is actually the main concerns, that the level of protections are not equal across all states. And there are no guarantees that states would not misuse provisions for their own purposes.
Wow. Mattia, do you have?
Yeah. Okay, so speaking of human rights, an article from Human Rights Watch affirms that the new resolution aims to, and I quote, investigate any imaginable criminal offense, even if no technology is involved at all. What do you think about this? And do you think that the resolution could pose a threat to civilians' privacy?
That's a big question that honestly, I'm not an international legal expert, but I'm trying to follow the process and also understand the contents, because the way how the treaty is written, and I discussed this with some of my friends who really in the field for many years, and I see that people also who are with the legal background struggle to precisely understand how the provisions will be eventually applied. So we need also to see at the factual precedents when the treaty would be formally adopted and ratified by 40 states and will eventually come into force. We need to see how this will actually be applied by states. But for now, I just want to give two specific examples probably. So there are Article 22, for instance, which grants states the authority to assert jurisdiction over crimes committed outside the borders if the nationals are affected, which would effectively allow other states to interfere in domestic affairs. This would also mean that if states want to use the conventions to prosecute the conduct of individuals outside the territory, they can do so. And in a way how, again, the formulations are put really broadly, this is the direct reading, but perhaps further interpretations would be provided in additional protocols or in the precedents where we will see how states would interpret the convention. The other Article 27, which is personally really interesting to me because I see a lot of similarities with the Article 32B, which was heavily criticized by Russia in the Budapest Convention, and then officially was cited among the reasons why Russia and few other states saw that there is a need for another instrument that would actually address the issue of this possibility of states to directly request data from service providers located in other jurisdictions, and thus essentially violate sovereignty. So that was a concern from some other states with regard to the Budapest Convention. But in the UN Convention, we see this Article 27, which I think is very similar in the way how it worded to the Article 30B, and I might be mistaken. But anyway, it says that states can access electronic data, which again is really broadly defined in the UN Convention, from individuals if they are located in the country, no matter where the data is stored. The same power in the same article is designed to order service providers that offer the services in the country to provide subscriber information relating to such services. And this may include, of course, phone, emails, account details, and other personal identifiable information. The article does not include specific and explicit safeguards, which the service providers may actually use before providing this information. But again, the question whether and how this should be read in conjunction with a really, as well, general human rights article in the treaty.
Thank you, Mattia.
Yeah, I have just one more question, and it's shifting the focus from civilians to companies or industries. So what could be the impacts of the resolution on industries or private companies, in fact?
So hopefully, again, I'd like to see both positive and negative sides. So I would start with the positive ones. So again, hopefully, those who are involved in, usually who are involved in the cybercrime proceedings, service providers, probably other companies that have necessary intelligence to support such proceedings, now will be able to do so in a more, let's say, transparent and institutionalized way, to have a better understanding what are the frameworks for cooperation between states. And I just wanted to highlight that this UN Convention, again, if it's finally adopted and ratified, this would not replace all other instruments that already exist. This would be just an additional way for states to streamline cooperation. So they may use either bilateral means, regional means, or the UN Convention if they prefer to do so. So hopefully for the industry and service providers, that would be a more sort of structured way, hopefully, depending again on the country and the jurisdiction and how it's applied, to take part and assist law enforcement investigations. On a negative concerning part, of course, the provisions directly regarding safeguards and human rights do also raise concerns on how the industry and basically service providers would handle such requests. The Article 27 that I just mentioned would probably also raise many concerns for users of service providers, whether they pass personally identifiable information without court investigations or oversight, necessary oversight before. And of course, in countries where higher level of personal data protection is already established, that would be a concerning point. But also the UN Convention was heavily criticized for provisions on confidentiality and transparency. Particularly the industry leaders argued that the treaty has too many references to keeping requests from states confidential, which might limit transparency and oversight. And of course, that already leads to concerns that some countries may use the data for surveillance and other purposes. But again, I would be cautious with the precise conclusions here. There are many other organizations that have a stronger position and calls to see real dangers of that. And I think that's really important that we can also have the position to analyze what are the pros and cons. But I would also like to see whether the states would also develop additional protocols to provide probably, hopefully, more clarity and specificity to the text, which is really, really, really broad.
It's actually pretty interesting that you mentioned this, but I think in the debate, it's pretty illustrative that it's the civilian society, civil society, NGOs, and the private sector that almost unanimously would vote against the convention, while the states can be grouped as, those against those for it and those sitting on the fence. It's notable that, the non-state actors, the non-state participants of this dialogue, and I would like to highlight that this is actually one of the few times where the UN and the governments are consulting those non-state participants, but they are heavily arguing against this law, and there are calls not to ratify this agreement, not to adopt this at the General Convention. So it's an interesting observation, and I wonder how would that affect the future of inviting non-state parties to the negotiating table.
Yeah, I would share your view. We've seen indeed industry and civil society for the first time to be on as a united front. And it was really interesting also to observe whether there would have a positive feedback on other processes within the UN. It's a really big question because even though some predict that once the states are able to agree on the first cyber treaty, that might affect the similar negotiations or discussions, I will call them discussions, in the first committee, where the same actually actors, Russia particularly, pushes for a cyber convention as well, but in context of the responsible behavior in cyberspace. And we know that in that committee, multi-stakeholders unfortunately didn't have the same possibility to be part of the discussions. It's really difficult. It's highly politicized process, and it's pretty difficult for organizations to even get accreditation to be in the room and to listen to discussions. Though the chair of the process tries as much as possible to incorporate multi-stakeholder segments, which are still criticized by industry and civil society, which are not really enough effort to hear those actors. But I wanted to also probably highlight that the treaty is so broad, and I think there are a lot of questions even from those who are really working in this field for many years. I mean, in an operational field, but also in the legal field. We plan to organize the expert discussion with some of the states involved on October 22nd, and directly ask them the questions, particularly also with the Article 27, how this should be interpreted, how this should be read and understood by those who would actually affect, by all of us. This would essentially affect all of us in the way how cybercrime will be addressed, but also how our security will be preserved. And hopefully we will get some more information, but I see really, despite the text is already adopted, I already see still attempts of different groups to question the necessity of this instrument to better understand different nuances, which I think is really, really great. And hopefully that could be a good sort of the blueprint for other processes in the UN, which of course are not ideal, but given that there's so many different actors with so different interests, so far I think that's really a success for multi-stakeholder participation.
Thank you. Well, since we are approaching this time when the convention should be adopted by the General Assembly, it's slated to be voted upon, I think, this year, sometime this year, although the deadline's been moving a little bit. But once this is adopted, what comes next? How this convention will be implemented on an international level, on the national level? What new demands it will create in terms of the nation state, what new pressure it will put on the law enforcement agencies or on these companies. Do you have any thoughts on this?
Yeah, just probably a few not comprehensive ones, unfortunately. But I need to first highlight that at the final session, which took place in summer, when states finally unanimously adopted the text. After that, several delegations took the floor and announced that they would make reservations in the application of the convention, meaning that they are not feel obliged to implement certain provisions where they disagree with this. Again, myself, I found this pretty interesting as a precedent which exists. I felt that is sort of the blanket obligation for states which once vote in favor of the text, that they are obligated to implement all the measures. but seems that that's not the case. So particularly Russia, while overall chose not to oppose the consensus of the convention because there were many really critical remarks during the final session from Russia, but still the delegations expressed dissatisfaction with the title. And it was really also interesting part where at the very beginning, I think entire day was spent arguing what should be the title for the convention. Russia wanted a really, and a few other delegations wanted a really more elaborate title with the focus and emphasis on ICTs, while some states preferred a more simple and laconic, which was eventually adopted, the UN Convention Against Cybercrime. Surprisingly, though, cybercrime is not defined itself in the treaty. So I found it's pretty interesting, while states did define what ICTs and ICT systems are. So Russia argued that it did not accurately reflect the document scope as per mandate of the ad hoc committee, and they highlighted that they dissociate themselves from the consensus on the title, and they would make interpretive statement when signing and ratifying the instrument. Iran as well was not happy with human rights provisions, and Iran actually took a final attempt to block certain provisions that they saw that would let states refuse international requests for personal data where there is a risk of persecution based on political opinions, race, ethnicity, or other factors. That was rejected. That was not a successful attempt from Iran, but again, despite this, the proposal received 25 votes in support, including from India, Cuba, China, Belarus, Korea, Nicaragua, Nigeria, Russia, and Venezuela. And after that, actually, I think it was Nigeria who also, once the text adopted, dissociated itself from specific provisions related to actually article related to the child exploitation materials and safeguards, saying that they are not consistent with the domestic laws already and cultural norms. That was a really interesting way to interpret and argue their position. And the other notable statement was also coming from Cuba, who raised overall broader concerns that were not happy that the treaty is not comprehensive enough, targeting cyber-enabled crimes. And they also pointed out ambiguities in different terms. They didn't like the use of dishonest intention, saying that it might be interpreted in many ways. So they also did not feel bound by certain provisions and explicitly said so. What does it leave us? Actually, in the end, it's a big question again. I think we need to see how the process goes through the General Assembly. But again, I'm really bad now with the predictions because I was the one who predicted that states probably would not be able to agree. But miraculously, they did agree on the final text. So if it is formally adopted, and I think there's already an appetite from certain states to push for additional protocols. It's a big question, what would be the language in those additional protocols? And they should be also ratified by a higher threshold. So this convention comes to force once it's ratified by 30 countries, while additional protocols should be ratified by 60 member states, if I'm not mistaken. With regards to, again, comparing to other existing measures, so my view is that it just adds another layer of available measures for law enforcement to cooperate with each other. One positive aspect is that many, especially developing states that are part of the regional frameworks, now could be also part of those international framework. And given that there are specific provisions on capacity building and technical assistance, hopefully they would help to develop the domestic laws in line with those who have a high standards. So that's the hope. But again, that's the big question as well with regard to established frameworks such as Interpol, how they would be integrated and whether there would be any collision in the way how electronic evidence is shared between the same law enforcement agencies. I think that's the question to those who are in the field to really study and understand better whether the treaty as adopted really has its own effect.
Fantastic. I think your remark on this miraculous unanimous voting is an important one, given how many truly irreconcilable differences are between all those different countries and all those other different players. It's nothing short of miracle that we now may have one global convention on fighting cybercrime. And in my view, that illustrates the importance of the topic and the growing role of the cyberspace in the day-to-day life of every nation and every person on the globe. But as you rightly mentioned, the actual implications on us, the citizens, the users, the people, the data subjects is yet to be seen. And it is very likely that the continuation of this process, the implementation of some of the norms, would create a lot more questions to debate. With this, I don't have any questions. Mattia, is there anything you would like Anastasiia to share? No.
I would probably say final point, if that's okay, that I think the major concern with any sort of negotiation initiative is that we don't have really reliable data to understand how existing frameworks already help. For instance, the data from the Budapest Convention is the most available from 2009 and 2010. So we don't even have information on how the Budapest Convention has two protocols, which, by the way, the second protocol is only ratified by Serbia and Japan, and nor any other Council of Europe member yet. But we don't have really understanding what are the core problems that law enforcement agencies deal with. Yes, we have a general information, but an efficiency of MLAT process, of the political will of certain states to cooperate. But given that we see the rapid development of different technologies, which are also accessible to private actors, but also law enforcement agencies in a way to access encrypted messaging, different capabilities to target to those suspected. So I think that's the main challenge. We still, I think, lack easy ways to report on cybercrime, easy ways to better understand what's going on the really level of ordinary users, as we all are, and better understand how this actually goes into the bigger picture, depending on the region as well. So maybe, I don't know, maybe this convention could be actually a reason for something more centralized approach, maybe at the UN level or at the level of certain states, to pull the data to better understand how the instrument is actually applied and where different advantages and disadvantages exist.
Well, I think it's an interesting point about transparency of this process and maybe allowing some glimpse into whether those instruments actually work or whether they may need a thorough reform. And in addition to what you have said, I think it is important that we need a clear distinction between cyber-dependent crimes and cyber-enabled crimes, and what should constitute the crime that clearly falls under this convention and what may not be seen as such. But I think, as you said, it is a matter of the future negotiations and a matter of practice. And for now, I can only thank you so much for your time, for your insights, and pleasure to have you here with us at ITSS Verona. Thank you very much, Anastasiia and Mattia, and we'll see each other again.
Thank you so much.
Thank you.